you.
For life.
Thank you. Good afternoon and welcome to the House Judiciary hearings. Today is March 24th, and we will start off with Senator Kramer, Senate Bill 156. It's good to see you, Senator Kramer. And you have 3 minutes whenever you're ready. I will also say that the chair has another meeting, so he will not be with us today. So you're stuck with me running the hearing.
Thank you, Madam Chair, and it's delightful to be with you and the Judiciary Committee. Ben Kramer introducing Senate Bill 156. And the purpose of this bill is that canines used for law enforcement purposes are worked very hard during their time of service. They very often need more veterinary services when they're retired than our family dogs. The issue is that when a canine used for law enforcement purposes is retired, there are two options. Either the dog is put down or the dog's handler has the opportunity to adopt the dog. In almost every instance, the handler will adopt their dog because it's their partner. The dogs live with them at home. The dogs go with them on the job every day. This is their partner that has worked with them, protected them, and quite frankly, saves a tremendous amount of money and resources for the public because the dogs will go in where human beings might not, because of the risk and the danger, and the dogs then take on that risk and danger. But once they're retired and the handler adopts the dog, they become completely responsible for all the costs and expenses of the canine. And often these handlers will have more than one dog retired, sometimes even 2 or 3 retired dogs at a given time. So the bill before you would require that the law enforcement unit that employs the canine share in the cost of those veterinary expenses when the dog is retired, so that that burden doesn't fall entirely on the handler, who, by the way, has a very limited budget already based on what we typically pay law enforcement personnel. The values that are in the bill were reached back in 2015 with the chiefs and sheriffs when working on the bill when it was first drafted. So the bill provides that in any given year, the veterinary costs cannot exceed $2,500, and during the lifetime of the dog cannot exceed $10,000. Committee, this bill passed Judiciary in both 2015 and 2016 and did not move forward in the Senate. The bill passed this year out of the Senate unanimously, both in committee and on the floor. And even my friend, Senator Huff, who I see is on the Zoom at the moment, voted for the bill. So I will proffer to you that this is a bipartisan bill with strong support. There is no opposition, at least in the Senate, there was no opposition. I'm not sure if that's been carried forward into the House. But with that, Madam Chair, oh, and by the way, the bill also, to offset some of these costs, provides that a law enforcement agency, both at the local level and at the state level, can accept donations from the public to put towards these costs. There have been animal welfare groups that have been willing to participate in this and contribute, but they were prohibited by current law from doing so. So under the bill, it would afford the local law enforcement as well as state law enforcement to accept these donations and then use them for this purpose. So with that, Madam Chair, I would certainly welcome any questions, and I hope for a favorable report from the committee.
Thank you, Senator Kramer. I see Delegate McComas has a question.
Hello, Delegate McComas. Nice to see you.
Thank you, Madam Chair. Senator Kramer, I really like the bill. My question to you is, the dogs have really bonded with their trainer. And so I'm assuming, I don't know if you can comment on this, but would it be hard for someone else outside of that, the trainer's family and the trainer to adopt the dog because the dog is so bonded with them?
Yeah, typically speaking, the department will not allow anyone other than the handler to adopt the dog. There's a lot of liability that comes with adopting a law enforcement canine, and they typically will not take the risk of having someone other than the handler adopt the dog, which is why, typically speaking, the options are the handler adopts the dog or the dog is put down. And as I noted in my introductory comments, it's an exceedingly rare circumstance where a handler will allow their dog to be put down because of the incredible bond that exists between the handler and the dog.
So even if the dog were a drug sniffing dog, it would be the same issue. In other words, I could see where, they definitely wouldn't encourage people that the dog was, ran after bad guys, but so in any situation, they don't allow that then.
Typically speaking, that is the policy in most of the departments because of the unique training and circumstances in which the dogs work.
It's a good bill. I hope
Thank you.
Like it.
Delegate Fisher.
Thank you, Madam Chair. Hi, Senator Kramer.
Hi there, Delegate Fisher. Good to see you.
It's so good to see you. I just had a quick question. Do you have, and I apologize, I logged in a bit late, so you might have already said this. Do you have a sense of sort of the numbers for this sort of bill, like a sense of how many we'd be looking at? And that was it. I also agree. It sounds like a great bill. I just was curious about that.
It's not a significant number. The fiscal note reflects for Prince George's County, which is the only one that they reference in the fiscal note, that there may be 5 dogs retired from service in a given year. And I think that was consistent with my recollection for Montgomery County. And actually, I take that back. The report shows that there are other departments that show roughly 5 dogs retired in a year. Natural Resource Police, 2 to 3 dogs a year is reflected in the fiscal and policy note. So it's not a significant number, but the cause can be significant for the handler, especially when they have 2 or 3 dogs. And in the past, we have had, and I don't know, Madam Chair, whether anyone has signed up today or if you're even taking witnesses in committee, but we've heard in the past where law enforcement officers have come in and said, look, the dog probably will live another 2-3 years after its retirement. So it's not a significantly long time that most of these dogs even live once they are retired. And they're usually retired on average after 5 to 7 years of service, unless they're injured sooner.
Thank you.
No other questions? Thank you, Senator Kramer. Very good to see you.
Good to see you, Madam Chair. Are there any witnesses? Again, I don't know what the committee's policy is. So if should I stay around or are we done?
Nope, we are done. We are doing sponsor only.
Great. Okay. Thank you very much, Madam Chair. Committee, great to see all of you. Stay healthy.
Thank you. You too. And that concludes the testimony on Senate Bill 156. Moving on to Senator Huff, Senate Bill 145. Hello, Senator Huff. Good
Hello.
to see you.
Good to see you all too.
And you can begin. You have 3 minutes.
All right, thank you very much. Senate Bill 145, actually it builds on a bill that I passed when I was in the House. Look at page 3, the language that we created was, and this was after the wake of Penn State. You may remember where you had the coach and people on the higher ups in the school that were involved in preventing and actually stopping the reporting of sexual abuse. So what we did was we created a law that on top of the mandatory reporter, that an individual may not intentionally prevent or interfere with making of a report of suspected abuse or neglect. And then it created a 5-year penalty. All this bill does is it doesn't change any of that current law. It just, right now, there is currently a 3-year criminal statute of limitations on this. This would just remove that. So there would be no, going forward prospectively, there would be no criminal statute limitations on the bill. That's all it does. Pretty simple. It's passed the Senate now twice unanimously, and hope the House will pass it as well.
Are there any questions for Senator Huff? Okay, seeing none, thank you very much. And that concludes the testimony on Senate Bill 145.
Well, see y'all.
Moving on to Senate Bill 109. This is a departmental bill, and Secretary Wilbon-Smith is here to testify in support of this bill. Secretary Wilbon-Smith. Hi.
Okay, thank you very much. Vice Chair Atterbury, nice to see you again. Thank you. And members of the committee, I'd like to briefly refresh your knowledge about the Maryland Safe at Home Address Confidentiality Program, or ACP as we call it. This program protects survivors of domestic violence and human trafficking by providing a substitute address and a free mail forwarding for eligible participants to use when interacting with state and local agencies, as well as with private entities. And through collaboration with circuit and district courts, public schools, the Motor Vehicle Administration, the Board of Elections, the Address Confidentiality Program makes the location of participants less accessible to an assailant by keeping the victim's actual addresses off the public record. So the substitute address serves as the public address, effectively safeguarding participants' residential address from appearing online. We currently have 1,210 active participants. Nearly half of them are children. And we have 25 participants that have purchased property under the yield shielding provision that's now been in effect for just a year. And I would tell you, we have an additional 11 that are currently in process right now as we speak. And we thank you very much for that support. What Senate Bill 109 does is to expand the address confidentiality program to individuals who are threatened and fear for their safety, but who otherwise don't qualify for the protection as they are not survivors of human trafficking or intimate partner violence. So we aim to empower individuals who have received substantive threats of violence to protect themselves from becoming victims of crime by keeping those residential addresses off the public record. Since that was established in 2006, we've had several Maryland judges who have sought to apply for address confidentiality, but were denied because they did not qualify because they weren't victims of trafficking or domestic violence. Last summer, a state prosecutor and also an employee of the U.S. Supreme Court who resides in Maryland also inquired about eligibility. And they each expressed a very strong desire to participate in our program, but because, and that's because of the professions that they're in, they feared greatly for their safety and that of their families. In those situations, we were unable to provide program participation because these threatened individuals didn't meet that eligibility. And so what Senate Bill 109 does, it allows a program to protect individuals who demonstrate substantive fear or legitimate threat to their safety. And using our existing resources, we would be able to keep the addresses of threatened individuals off the public record and indeed likely preventing violent crime. The other thing the bill does is it consolidates two programs, the address confidentiality program and the human trafficking address confidentiality program. They're very similar. The wording is almost identical. And this bill, Senate Bill 109, did unanimously pass the Senate. And I asked for a favorable vote for Senate Bill 109. Thank you very much. I'm happy to answer any questions.
Thank you, Secretary. Are there any questions? Delegate McComas? You're on mute. Delegate McComas.
I
You're muted.
had a great bill in the Judiciary Committee, 686, didn't get a vote. So it's crickets. So what I'm wondering is if the judiciary and let's say the public defenders and the prosecutors want to be able to use your program, could they do that if this passes?
Yes, if they're subject to this risk and that is certified, absolutely, they would be part of it.
Well, then when you say certified, what does that require?
Well, we actually look at, we'd have to have some substantial indication that there's been some specific threat against them.
Okay.
And that's all as part of the vetting process that we currently do with all of our subscribers, all of our participants in the program.
Well,
So
I think
wouldn't
I think
change
I may
any of that
wanna-
at all.
Yeah. Well, I think I may want to talk to you offline. 'Cause, anyway, so thank you. I think it's a
Sure.
good.
Delegate Sham?
Yes, thank you, Madam Chair. Welcome to Judiciary, Secretary Robin Smith. Thank you.
Thank you.
I just want to make sure I understood correctly. Did you state that persons who would need this type of support, if you will, that a substitute address is
Yep.
recorded somewhere?
Yeah, what happens is that all of the entities that I talked before, the courts, the schools, the Board of Elections, all have been participate with us in making sure that the address, which is actually our address, 16 Francis Street,
Oh, okay.
where all the mail comes to. And then we package that up and send that on to the secret address where the people are living. So that is kept very confidentially. I actually when I got here, I made sure that we had a completely separate computer that was not connected at all to the internet so that no one would be able to come in, hack into it and get people's addresses. So we've been very, very strict about ensuring the privacy, and it's worked well.
Yes, thank you very much. It's a great bill. Thank you.
Thank you.
Any further questions? Seeing none, thank you, Secretary.
Thank you very much.
And that concludes the hearing on Senate Bill 109. Moving on to Senate Bill 267, another departmental bill, and Michelle Farr is here to testify in support of that.
Yes, good afternoon. Thank you so much. Good afternoon, Madam Chair, Vice Chair, and the members of the committee. I am Michelle L. Farr, Executive Director of the Social Services Administration within Maryland's Department of Human Services. And I am extremely appreciative to be before you today to testify in support of the Senate Bill 267. As you are aware, the current law requires the local Department of Social Services to report any preliminary findings of child abuse to the state's attorney's office within 10 days of opening a child abuse investigation. So Senate Bill 267 would remove this reporting requirement. The local departments have made tremendous efforts to refine their practice model in a way that serves both the child and the family holistically. And this model, which includes a multidisciplinary team, includes our state's attorney's office. So as such, we believe this reporting requirement has become obsolete in the light of the improved coordination between the local departments, our prosecutor's office within the local departments of social services, and our Child Advocacy Center. I wanted to just share briefly about our Child Advocacy Center model because it is comprised of a multidisciplinary team, which also includes our law enforcement, our legal services, protective services, our victim advocates, and our medical and mental health services. So access to a comprehensive offering of services within a one-child friendly facility is critical to the child's health and well-being. Without a multidisciplinary team to coordinate care for the child victim, the child may end up having to share very painful details about their abuse repeatedly to doctors, police officers, lawyers, therapists, investigators, judges, and others. So the CAC model minimizes the traumatization by having one streamlined intake process that is followed up with wraparound services. So with this practice model, the Office of the State's Attorney is involved in a child abuse investigation at the onset of the case. So there is no longer a need to issue a separate report of preliminary findings because the local department and the law enforcement conduct a joint investigation in many situations, and the sharing of information with the prosecutor at the conclusion of the investigation does occur. So this reporting requirement does not serve any meaningful purpose, does not complement our current practice, and creates an unnecessary procedure for our local department staff. So thank you again for the opportunity to testify in support of our Senate Bill 267. We appreciate your support, and we continue to improve our delivery of services and streamline our processes. And we are asking that the committee give Senate Bill 267 a favorable report.
Thank you. I see a question from Delegate Crutchfield.
Yes, thank you very much, Vice Chair. Just a quick question, Ms. Farr, are you confident that all the counties are using this particular model right now? And what gives you that confidence that that's occurring?
So the excellent question. Thank you very much. I am extremely confident all of the jurisdictions have a CAC available to them, and we are extremely confident that we are utilizing that. What I would share is that our investigations are typically initiated within 24 hours for abuse or 5 days for neglect. There's a 60-day closure requirement, and typically the CAC adheres to our mandated requirements in conducting the multidisciplinary meetings. The other thing, though, I would like to share is that requirement by COMAR is that we are required within 5 days of completing an investigation to submit a final report to the state's attorney's office by any agreed means, which includes a report of physical examination or of treatment if performed, and regarding the alleged victim. So there is a notification that goes to the state's attorney on every physical abuse case. And as you may know, the Maryland State's Attorneys Association also supports this bill, as well, of course, our local departments.
And Vice Chair, one more question, if I can.
Yep.
Ms. Farr, and what is the real oversight to ensure that the cases will actually be closed within that 60-day period of time? What kind of oversight is there?
So we have a system of record, which is called our Child, Juvenile, Adult CJAM. So it's Child, Juvenile, Adult Management System, CJAMs, which we are able to go in and to see the status of our cases and ensuring that our cases are closed within our 60-day time frame. We also, of course, conduct supervisory reviews that allows us to also ensure that we're meeting that requirement.
Thank you very much.
Very welcome.
Delegate Erican.
Thank you, Madam Chair. Hi there, Ms. Farr. So I just want to make sure I understand how the process works right now and what will be changing. So right now, you guys send something over to the state's attorney's office. What does the state's attorney's office then do with that information? Is it just so that they can also keep a record of who's being investigated?
So to be perfectly honest with you, I believe the reason why, and I don't want to speak for our partner, but I believe the reason why they are in agreement with this bill is because it does not necessarily serve a purpose. When we are conducting our investigation in that 10-day time frame, rarely are we able to have a finding. So we are still in an investigative investigating. We are still investigating the referral or the allegation. We have not completed or rendered a finding. And so it's just, and I guess it's an alert, but from my understanding, it has not been meaningful at all, because the state's attorney is already engaged in conversation with us through the multidisciplinary team activity.
Okay, and then you did say to Delegate Crutchfield, each county has a CAC now?
Correct. And
Okay.
with that, I will also say, again, we have our time frame at closure where we also have to report out to the state's attorney's office. I think the key thing here is that this current practice does not align with where we are in terms of best practice and how we have moved forward in our coordination with the other partners within the community to address these needs of our community and the children as victims. So it's really eliminating what I believe someone may have shared in previous testimonies, reducing the red tape and the inefficiencies in government in terms of filing a preliminary report that really has no use.
Okay, so there's another report that comes later. So this is a preliminary one, and then at what point does the state's attorneys get the next report?
The state's attorney will get the final report of our findings, 5 days maximum, right? We're required 5 days to report out to the state's attorney once we have made a decision or rendered a decision as to whether or not there was any allegation, if those allegations were indicated, were they ruled out, or were they, there are three different, it's unsubstantiated, ruled out, and indicated. But either way, we will be notifying the state's attorney 5 days after rendering our decision.
And then what do they do once that happens? They decide if they want to prosecute somebody, if it's a fact sustained or whatever?
Yes, and usually them deciding to prosecute happens throughout the duration of the investigation.
Okay, so they don't wait for your report. They can go ahead and move forward with criminal charges.
They're engaged at the beginning of our process, and so they can make a decision as we are moving forward with our investigation to determine whether or not the information would warrant their investigating.
Okay, and then
But
there's
in
two
terms
sort
of
of
a written
simultaneous
report-
investigations at that point. If they,
Yeah.
so then you guys continue yours, they continue theirs.
Well, the goal is for us to work in tandem with one another, and that's a part of the partnership, to reduce, and through the multidisciplinary team process, to reduce a victim having to recount what they may have experienced. And so a part of this process is to participate in the multidisciplinary team, which includes our state's attorney's office as well as our law enforcement. And so we do that with the CAC partner.
Okay, all right. Thank you very much, Madam Chair.
Delegate Cox.
Thank you, Madam Chair, and thank you, Ms. Farr. I appreciate your testimony. I have a quick follow-up, I guess, on what I just heard. Isn't it more likely, though, that information sharing, if you're going to pass this bill that does not mandate information sharing with the state's attorney's office, that cooperation will actually diminish potentially, because now you're having information that's being withheld from the state's attorneys at the same time that they might be interested in investigating something?
I would have to say that Delegate Cox, that I would not agree with that, respectfully, because again, the state's attorney's office, as well as the law enforcement office, are notified when we are getting our child abuse investigations. And so they have the opportunity to participate with us in those multidisciplinary team processes. And they can make the determination as to whether or not they would like to move forward with prosecuting.
But doesn't this mandate, though, that a formal documentation of maybe the interviews, the intake form, the notes, the analysis sheet of the supervisor, that all be provided to the state's attorney's office? But if you pass this, then there's no mandate to provide that information, right?
So this mandate would still be our process would not change because of this bill. This bill, to my understanding, was created back in maybe 1987, right? And the way that we're practicing now, this bill would support us continuing to communicate and providing that information. I don't believe we need a mandate to be able to do that. Our partnership has really strengthened with our state's attorney's office as well as with the law enforcement through the CAC multidisciplinary team activity.
Well, I know that, in my interaction, I appreciate greatly the members of the Department of Human Services and the DSS in terms of how they protect our children. And one of the aspects of the tools that I appreciate the most is the statutory timeliness that is mandated, because that's when you begin to obtain information. And this just seems like less transparency. So that would be my concern. But thank you so much.
You're welcome. If I can say that it's in my experience, there is a very small number of investigations that the state's attorney would be interested in prosecuting involving our child abuse based on the burden of proof for a criminal case. However, again, through our multidisciplinary team process, the state's attorney and the law enforcement, we are in there together with our CAC partners, interviewing the child, and the determination as to whether or not they wish to pursue prosecutory processes. They can determine that throughout the life of the investigation. So, but as a follow-up, there is the opportunity that we're required to still provide them with our final finding at the end of our investigation for them to also have for future reference.
Thank you, Ms. Farr. And that concludes the testimony on Senate Bill 267. Moving on to Senate Bill 222, another departmental bill, and with us, James Johnston to testify in support. So, Mr. Johnston, you have 3 minutes.
Thank you very much, Vice Chair, members of the committee. Thank you for the opportunity to join you today to speak briefly about Senate Bill 222. My name is James Johnston. I'm the Legislative Director for the Department of Juvenile Services. So Senate Bill 222 is really spurred by the reauthorization in 2018 of the Federal Juvenile Justice and Delinquency Prevention Act and the changes to the jail removal part of that federal law. Now, the important thing is if you are not as a state in compliance with that law, you can lose funding. It would be here about 20% of $1 million, so about $200,000 a year. So one of the prime goals of this bill is to bring us into compliance. To do that, we need to make sure that any youth who is charged as an adult has the ability to be held in a juvenile facility pending disposition of their case. So right now, the current law allows a judge, and in fact requires a judge, to house a youth who is eligible for transfer. In other words, they are in the adult system, but they can petition the court to be returned to the juvenile system with the Department of Juvenile Services, unless they're released on bail, of course. So we have housed those youth really since 2013 by agreement with stakeholders in Baltimore City, and then beginning in 2015, after this body changed the law, we've housed the vast majority of those young people safely and securely, and we can add additional youth in without incurring a cost to meet the requirement. An example of that would be under the current law, a young person who is waived out of the juvenile jurisdiction, so say a 15-year-old, would be, if they're detained, to the county detention center. There would be no statutory authority to remain at the DJS facility. This bill fixes that, and it increases the categories of young people who can be held in secure juvenile facilities until they have a disposition. Young people who are sentenced would be sent to the Division of Correction, as is the current practice, but we detain young people until they turn 18 in our facilities unless they're sentenced until their case is resolved. This bill also does some important things to make sure that the time frame for transfer cases is addressed by making sure that the administrative judge rules on those postponement requests, so they have eyes on it and they can make sure that there's not undue delay. And the bill also makes sure that the community detention operation, which we run now, would be available to youth who can be released, and a judge believes it's appropriate to release them, but they need to have some sort of electronic monitoring or other supervision pending. So we would be able to use our existing resources to supervise those young. I know that's been a concern of this body, including Billy Smith's bill. I believe it's HB 316, in terms of making sure that detention options in the community are available to everyone, regardless of their ability to pay. We support the bill, of course, as amended. I say as amended because we've been working with our partners at the Office of the Public Defender on amendments to address some of their concerns and make sure that operationally this bill does exactly what we want it to do. So we have been in contact with them. I know they had some additional amendments that they proposed, but I can tell you that they support our proposed amendments, which we hope to submit soon. We'd like the bill to function operationally as best as it can to make sure that we have those youth in our facilities safely and securely. So with that, I'm happy to answer any questions. Again, this bill brings us into compliance with the federal law. It adopts the federal statutory standard, which a judge can use. And if a judge believes that a young person would be an undue risk to be housed in a juvenile facility, as is the current law, the judge can override that and detain them in a county detention center, for example, pending the outcome of their case. So with that, thank you very much for your time, and I'd be happy to answer any questions.
Thank you. Are there any questions? Seeing none, that concludes the testimony on Senate Bill 222. And Mr. Johnston is also here on Senate Bill 146, and you have 3 minutes for that as well.
Thank you very much, Vice Chair, members of the committee. James Johnston again with the Department of Juvenile Services here in support of Senate Bill 146. It's a very simple bill, one-line bill, but it does something that's important to our agency. Right now, we have 2 deputy secretaries. One oversees our facility operations, so detention facilities, committed programming. The other deputy handles the support services, so all of the back office needs, HR, IT, procurement, et cetera. We have an assistant secretary who handles the community operations. Community operations would include probation, intake, all of our offices throughout the state who supervise young people and deal with them and treat them in the community. This very simply add a 3rd deputy secretary. We would move over that assistant secretary to the deputy secretary position, and we would have the community operations receive the support and leadership it deserves. It's a very important part of our operation. You all heard HB 1187, which was the Juvenile Reform Council proposals, and certainly we see more young people being treated in the community, served in the community. That leadership is important. There is no fiscal note to this. There is no additional cost since we would be essentially taking the assistant secretary and moving them into a deputy secretary position. So with that, we would ask for your favorable report. There was, I think, on both bills that I testified on, the Senate was unanimous in terms of their committee decision and also on the floor. So with that, we'd ask for your favorable report. Happy to answer any questions.
Are there any questions? Seeing none, that concludes the testimony on Senate Bill 146. Thank you very much, Mr. Johnston.
Thank you.
Committee, that concludes the hearing for today, March 24th. I will let you know that tomorrow we are hearing the Senate policing bills, but unlike when we heard our bills, we're not going to hear 500 witnesses. There are a total of 9 bills and there are set panels and there'll be 33 witnesses, but that is tomorrow. So with that being said, thank you very much. See you all later.